Welcome once again to Lehto's Law. Here's Steve Lehto.
Don sent me a note about a story out of New Jersey, and it has to do with when the police can search a car at the roadside in New Jersey. And it seems to be an ongoing debate as to exactly what facts allow it and what facts don't. But the Supreme Court of New Jersey has now ruled that a traffic stop that led to weapons convictions was unconstitutional. And the facts are interesting. So Sophie Nieto Munoz wrote this for the New Jersey Monitor. The ruling this week by the New Jersey Supreme Court reverses the weapons convictions of two men who were arrested after the justices say the car they were driving in was illegally searched. The state Supreme Court on Tuesday reversed the weapons possession convictions of two men after finding in a unanimous ruling that the traffic stop that led to their arrest was unconstitutional. But the court stopped short of agreeing with the defense attorneys and the ACLU to adopt a rule requiring officers making traffic stops for suspended licenses to first confirm the driver of the car they're pulling over is the person with the suspended license. Instead, the court said it will leave that issue to lawmakers. So the ruling is the first time that the New Jersey court has considered whether the analysis behind a 2020 U.S. Supreme Court ruling on traffic stops supports a comparable approach in New Jersey. In the 2020 case, the U.S. Supreme Court ruled it is reasonable under the Fourth Amendment for police to stop vehicles registered to people with revoked driver's licenses. But let's ask the question. Suppose they're just driving along and they run a plate. And the plate says that car belongs to Steve Lehto, and his license is suspended. And as they're observing, they realize, oh wait, the car is being driven by a 16-year-old girl. Well, do they pull the car over and go, hey, well, we ran the plate, it's for a suspended driver, knowing that the suspended driver's not behind the wheel? That's the big question. So the New Jersey decision goes all the way back to 2016. There, a police officer searched for information on a Nissan he spotted during a traffic patrol and found that the owner was a woman with a suspended driver's license. He pulled the car over and found two men in the car. That should be your first clue that the person with the suspended license is not the person driving the car. So there's two men in the front seat, one driving, one of the passengers. The men explained they had borrowed the car from its owner, and they did actually phone the owner during the traffic stop and say, oh, by the way, we just got pulled over in the car you lent us. So the officer called for backup, claiming he might have smelled marijuana. He might have. I thought they taught you at the academy to say you do smell, not that you might smell. He said that was while he was outside the car, but he was too congested to be sure. So apparently he had some cold or flu symptoms. Another officer arrived with a canine to sniff the car, and one of the people in the car told the officer that I can't really give you a consent to search the car because I'm not the owner of the car. So you need to contact the owner. And the officer said, well, that's not true. I don't need to do that. So the dog found a little marijuana under the car's passenger seat, and the officers arrested the two men, and a further search of the car revealed a gun, and that was a problem under the driver's seat. The justices unanimously agreed that the initial officer should have let the two men proceed after finding that the driver was not the owner with a suspended license, and that the cops' uncertainty about the odor of marijuana wasn't enough to justify a search of the car. They don't have a warrant. Do they have probable cause? I might smell something. I might. And this is from the ruling written by the court. Therefore, immediately upon observing the occupants of the vehicle, the officer should have done no more than explain that the vehicle had been inadvertently stopped and told defendants they were free to leave. The ruling reverses the convictions of the two men, since the evidence against them was seized during an unconstitutional search of the car and should have been suppressed at trial. They each had been sentenced to 15 years behind bars, and obviously this happened a while back, so I suspect they've already spent a few years locked up. The state attorney general's office presented worrisome data on traffic stops. And that was actually part of the opinion. Over a 10-year span, nearly 30% of drivers suspected of driving on a license or registration violation were not ticketed, suggesting that in some cases the drivers being stopped are not the owners of the vehicles, or it's simply a pretext to pull people over. Cars can be owned by one person and driven by other people, and those sharing arrangements are more common in households that can't afford multiple cars. A lawyer for the defendants did not respond to a request for comment. And, I've driven other people's cars before. And when I was growing up, I've mentioned before, I had a whole bunch of brothers and my parents. And so there was often a whole bunch of cars in our driveway or in our garage. And so there were times when my brother might jump into the car I normally drive, or I might jump into the car my mom normally drives. Now, none of us ever got our licenses suspended as far as I know. But this is a pretty straightforward one. Police officer runs a plate and it goes, oh, the person to whom this plate is associated has a suspended license. Police officers pull the car over, walk up, and immediately realize that that is not the person with the suspended license. So the reason for the traffic stop vanishes. At that point, as the judge says, should have said, sorry, just pulled you over because the license came back to a suspended driver. Wanted to make sure it wasn't you. It ain't you, obviously. Have a nice night, guys. Sorry to bother you. But no. The officer says, I might have smelled marijuana. Calls in backup and a canine. And the canine does find a small amount. And actually the terms from the opinion says a little marijuana. I'm assuming they would have measured it. But then again, they weren't apparently charged with that. They were charged with the weapons offense. So that's the problem. But I believe this is a good ruling. And this is one of those things. I've done a lot of stories on this channel. In fact, I was actually looking the other day at the top performing videos on my channel. And the number 1 or number 2 video is, when can the police search your car at the roadside? And it's a question that is very, very difficult to answer. And the reason is that, number 1, there are 50 different states, and there are different laws in some of those states that change what the police are allowed to do in that state. The other problem, of course, is that every set of facts is different. And so we've heard stories before where the police are driving along and they run a plate and the plate is expired, or the plate is no good for whatever reason. And they pull that person over. Can they search that car just because the plate is expired? That kind of thing. And so here we have it where, the driver of the car wasn't who they thought it was, but if it had been the owner of the vehicle, that person would have had a suspended license. So it makes sense that they can at least investigate. But here where, the owner is a woman and the man driving is a man, you'd think that that'd pretty quickly answer their question. Now, I believe that in most states, a police officer encounters somebody driving can ask to see a driver's license. But beyond that, there's nothing else to indicate that they had the right to search the car. And so there is that little wiggle room there with the little marijuana that they found, and the police dog appears to have located it. But beyond that, no. So the New Jersey Supreme Court has said, no. This stop was okay, but the car search was no good. Throw it out and let these guys out. So traffic stop happened in 2016. Does not say when they were convicted, but they spent a couple years behind bars. For those of you who don't like to hear about these stories where people get off. So from the New Jersey Monitor, and Dana sent it to me. I may have said Dan at the top. I apologize. Dana sent it to me. Sophie Nieto Munoz wrote that. For the New Jersey Supreme Court has ruled traffic stop that led to a weapons conviction was unconstitutional because they had no probable cause to extend that traffic stop or search the car. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Be thankful for what you have. You'll end up having more.